conflicts in a manner that's most protective of coastal resources. And one more point I should add is that this issue also came up in the tunnel project, and the tunnel project is another exception. George mentioned the 1998 amendment. The tunnel project also in the Measure T language that went into the LCP, and that amendment itself is viewed as providing this type of analysis for us to proceed on the tunnel project itself.
Did we get her back just in time?
Yes.
Sorry, George.
Can I ask a question then? You're recommending some other language be incorporated. Are you prepared to disclose what language you're
Well, what I'm looking for from your commission is the direction, and when we have the wrap-up meetings in a couple of weeks, or a couple of months.
Oh, aren't you
I'm
an
gonna-
optimist?
Right, a couple of months. I'm going to be coming back with the exact
Okay.
ordinance language for all of the
All right,
approvals that
all
you've
right.
given. You've been giving conceptual approval to these, and I'm going to come back with actual formal recommendations. I will tell you that I see it be the future LCP policy that I'll be proposing will be modeled off of this, and it will say when there are conflicts between two LCP policies, those conflicts shall be resolved in a manner that's on balance, most protective of significant coastal resources. That's probably the way the future policy will read.
Okay. If we tell you to do that.
Right, that's right. And that is
After we've heard from the public, and considered public input. Any other questions? Okay.
I'm going to now move on to a very different topic, which is Task 23. This calls for developing an impervious surface zoning standard and evaluating the county's non-point source pollution controls. In terms of background, non-point source pollution is pollution caused by diffuse sources and is normally associated with surface runoff. For example, when it rains, water can collect contaminants as it flows and deposit them in lakes or streams. Generally, non-point source pollution can be controlled by maintaining or increasing the land's ability to retain water. Hence, the more pervious the land, the less the surface runoff and spread of non-point source pollution. An impervious surface is a surface that cannot be penetrated by water, such as pavement or concrete. Impervious surfaces can alter natural drainage and adversely affect water quality. Generally, the more impervious surfaces, the more potential for water pollution, erosion, sedimentation, and flooding. Through the Federal Clean Water Act, the Bay Area Regional Water Quality Control Board issues National Pollution Discharge Elimination System permits, or for short NPDES permits, to local government agencies that regulate development. For San Mateo County, the Regional Board has issued an NPDES permit to CCAG based on the existing county-wide, and here's another acronym, STOP, Stormwater Pollution Prevention Program. The County Planning and Building Division administers the STOP program for the unincorporated area and requires best management practices for new development. Such practices can include requiring erosion and sediment control plans, requiring designs with less grading, and restricting grading during the wet season. They also can include berms to direct runoff to pervious areas, ponds or swales to collect runoff for soil infiltration, or the use of a detention basin to store water for later release after a storm. In addition, biofilters, filtration strips, and vegetated depressions can filter pollutants. During construction, best management practices include requiring that all exposed areas, equipment, and building materials be covered. In addition to the STOP program, the existing county grading regulations require preparation of an erosion and sediment control plan, and such plans call for retaining existing vegetation wherever feasible, minimizing the steepness of slopes, stabilizing denuded and disturbed areas, seeding slopes after grading, and diverting runoff away from denuded areas. The grading regulations also require adherence to grading performance standards, compliance with a dust control plan, and the planning director may prohibit winter grading. Turning to our zoning regulations, the existing lot coverage limit is the zoning standard that comes closest to an impervious surface limit. Currently, lot coverage applies to all buildings and structures higher than 18 inches. In other words, the lot coverage standard does not limit the amount of pavement, patio, or ground level impervious surfaces. On the other hand, if we were to have an impervious surface limit, such limit would restrict the amount or percentage of a parcel area that could be covered with ground level, non-porous, or impermeable material. With such an approach, when an impervious surface limit has been met, the remaining parcel area could either be landscaped or porous materials could be used, and there are porous materials such as pervious concrete, porous asphalt or brick, and naturally porous stone. At the community workshops for this task, we discussed 3 options. The first was the status quo alternative, which is to maintain the existing STOP program and endorse future improvements. The second alternative discussed was to establish an impervious surface limit separate from lot coverage, and specifically that the alternative would limit impervious surfaces to 10% parcel size and applies only to structures that are less than 18 inches in height, such as ground level pavement or patios. So with this alternative, you would be measuring the buildings and the larger structures. I mean, you'd be limiting the amount of parcel coverage of the buildings and larger structures with the lot coverage requirement. But we would be, if this was adopted, we'd be introducing a new regulatory standard which would apply to that development that's not covered by lot coverage vis-a-vis the ground level development that's less than 18 inches, which is where you typically find the pavement, the asphalt, the cement, and then the proposal that we have is a 10% impervious surface limit, meaning that if you had a 5,000 square foot parcel, no more than 500 square feet could be covered with ground level concrete, let's say, or asphalt, and after that you would either leave it landscaped or choose to use porous building materials, and there are porous concretes, there are porous bricks, and things like that. The third alternative was to prohibit grading during the rainy season, which is October 15th to April 15th, regardless of whether a formal grading permit was required. That would mean for all construction. At the workshop, all of the participants who spoke on this task endorsed maintaining the STOP program. They also endorsed having a 10% ground level impervious surface limit, and they endorsed regulating but not specifically prohibiting winter grading. And I'm going to now go to the differences here. These speakers were divided on the application details for both the impervious surface limit and the grading controls. Specifically, most of the speakers, 88% to be exact, endorsed applying the 10% parcel size impervious surface limit, but they preferred a provision that would permit additional impervious surface coverage for non-residential uses when it's demonstrated that there'd be no added off-site drainage. This would be accomplished by submitting a professionally prepared site plan showing topography and off-site drainage, such that drainage from impervious surfaces does not exceed 10% of parcel size. What that means is, at the workshop, it was recognized that some non-residential uses require more hard surface, usually because of parking requirements and other things, and it would be maybe too onerous to limit the impervious surfaces to 10% for the non-residential, but you could permit it so that no more than the equivalent of 10% ever ran off the site. So what was being discussed is if someone had developed a plan for non-residential where they had, let's say, 20% impervious surface, and they could show through catchment basins or rerouting water or whatever, or cisterns or whatever, that the added 10% would not go off as runoff, it would have the same effect, and so this was felt to be a reasonable approach. Regarding winter grading, most of the speakers, again 80%, endorsed permitting winter grading only if there was rigorous site containment requires to prevent erosion and sedimentation. It was more outcome-based. The people at the workshop said, well, they didn't endorse a prohibition just to have a prohibition. They just want to make sure that there was no erosion and sedimentation during the winter, and if it was all a matter of process. If it could be regulated tightly, that things were covered and things were protected, and exposed surfaces were not. I mean, surfaces weren't exposed during the winter, then it could be permitted. So, with that background of the workshops, we'll now look at the staff and Mid-Coast Council recommendations as I wind up the presentation. These are on the screen. The staff and the Mid-Coast Council are in complete accord with every element of this recommendation. So, Both staff and the Mid-Coast Council are recommending a 10% parcel size ground level impervious surface limit, but allowing an exception for non-residential development, providing that there's no added runoff over that 10%. Both the Mid-Coast Council and staff are recommending that we maintain the existing stop program, including best management best management practices in the, that are in the county's NPDES permit, and that, of course, means also working with the regional board to continue to improve that program and the permit as well. And also the third part, both the Mid-Coast Council and staff recommend permitting winter grading when rigorous site containment occurs to prevent erosion and sedimentation. So that is,
Jordan,
yes.
before you take this away, just as an aside, I'm puzzled by how the acronym STOP has got out of the Stormwater Prevention Runoff Control, or whatever that is. I see no relationship.
Storm is S-T-O. and then
Storm
there's
is
two
spelled
P.
S-T-O.
And then there's two P.
And
then
pollution is spelled with a
Pollution
T.
Prevention Program, right.
What?
It's not a true,
Yeah.
it's not a true acronym. It's
Okay.
a,
We should say stop
Surrogate.
acronyms, but anyway.
It's not an acronym.
Okay.
not strictly.
I'll ask Candy to switch over. I've consolidated the recommendations for both tasks on one visual, and I'm going to leave that on the screen and then open it up for public discussion. And that would conclude my staff presentation.
Okay, thanks very much. And, George, as usual, that was excellent. We'll open the public hearing without further ado. If there's anyone who hasn't handed in a speaker slip, please do. That gives us 5 speakers, 6 in total. The first speaker is Mario Pellegrini, to be followed by Leonard Warren. And, of course, all speakers, I think you all know to state your name and address for the record when you get to the podium. And if you can make your comments within 3 minutes, that would be wonderful.
This is Mario Pellegrini, resident in Montera, and I've got 2 points I'd like to address. One is a carryover from the experience we just had on the previous issue, just as an example, but not to refer to the issue again. And that is, we're talking about standards and regulations, environmental protection, and we have standards, and I was calling for the standards to be adhered to. If you meet all the standards, you should get your approval and so on. Now, without losing Mr. Wong's vote forever, I want to say that he made the statement that, yes, this house met the height limitation, but I'm just not happy with it. I worry about that. And so it brings into question in my mind, as somebody in the public here, we have standards, but if the people who rule on these can say, yeah, you met the standard, it's so many feet, it's so many inches, but I just don't feel good about that. So you're in between a rock and a hard place. The 2 things that I came here to address were the height standards on homes, from 36 feet to the lower to 37 or something, and the square footage limitations on the home on the property. And I particularly think that when you talk about acreage lots, parcels, that these 2 kinds of limitations are, economically infringing on the private property rights of the individuals, but also very inappropriate when you have all the standards, 1 house per parcel, can't be seen from a scenic corridor, 36 feet high, can't break the ridge line, you go on, and then you want to take and diminish those. And I still have this problem. If you can't see this house, what is the concern expressed by the public? Certainly not by me, but who comes forward and says, oh, we've got to cut these houses down. We can't let them build a house 36 feet high if it can't be seen.
Mr. Pellegrini,
Yes.
if I can, your comments may be very appropriate to another part of
Okay, not
the
these.
local coastal program, but what we've got before us right now
Okay, I'll get
If
off
you can
that.
tie it in, if
I'll
you can
get it off right now. I'll just say that
tie it into what's before us
yeah,
today.
okay. The thing that was said earlier by the staff is that it'll be months maybe before we really get these things resolved and get them into the law and so on. And as people in the public, it's very difficult for me. I have a job and responsibility to stay on this thing because it'll come up again. It's like waves on the shore. If it doesn't get through this time, in 6 months from now, it's going to be entertained again, and it's going to be entertained again until it gets passed. So the process, again, I see as being used as a tactic to get what it is wanted by the people that play. The final thing I have to say is somewhat different, but it's about the information that you get from the public here and the things that you are used to make your judgments. And I attended the previous meeting on March 9th. And at that meeting, one of the representatives of the MCCC, the chairman of the MCCC, Miss, let me see,
Would that have been the Board of Supervisors meeting?
no,
Because we didn't meet
no,
on,
it was the planning meeting.
wouldn't have met on March 9th, I don't believe. But
Miss Carter came before you and outlined the fact that, well, let me just quote from the videotape that was made at that time.
certainly, may have been another day, but go ahead and make
Oh,
your point.
I'm not sure about the date.
No problem. Go ahead and make your point.
She said that on behalf of the Mid-Coast Council, Ms. Carter, on their stationery had a thing about the height of houses and the square footage limitations. But she presented some maps in Montera and referred to sections 13 and 14 on the map and made the statement that this area has a lot of substandard parcels on it, but that they would never be approached to have water and sewer services from the Montera Water and Sewer Department, that they were very small substandard parcels, and she was asking you to entertain the idea of allowing them to become merged, these small parcels. And she referred specifically to the 30 or 35 parcels that she owned, because she lived in section 14 of the map in Montera, where this boundary line for the service area of the Montera Water and Sewer Department was being put forward. And so she...
I want you to be able to make your input, but I don't think
Your mic.
Oh, thank you. It's not clear to me how the comments you're making are germane to the two items before us today, and what I was going to suggest, since it sounds like all the things we've been discussing over the local coastal plan update are coming back to us for one final thing, that you might want to put this down in black and white, be sure we get it, and then when we get to that wrap-up, if you can be here, you can speak to it too, but at least we've got what you're saying in black and white. But
All right.
don't think what you're talking about is before us today, and we're probably going to forget it by the time we get to
validity
it.
of the information that comes to you from the public. It's the validity of the information. That's why I'm bringing it up.
Okay,
If you make judgments based on information that's invalid in some way, and I'm not being accusatory, I'm asking a question here.
We
Whether
certainly
this
would
is-
try not to, but yeah,
That's
if you're
right.
saying that you're saying, your contention, then I'm understanding is that information may have been brought to us, you're not sure that
Right.
you have raising question whether that was correct information, and what if we make it?
I can finish in a minute.
I'll let you do it, go ahead.
She then appeared where she is chairman of the MCCC committee on the coast, and was called out of order by her fellow board members because she had gone unilaterally to this organization. And she states in the tape when she was here that she was doing this prematurely, and she had not brought it up with her group. But they were concerned that she had come and made propositions without their approval unilaterally. So all of it, as a person in the community, going to these meetings, trying to keep up on my community activities, question whether or not this is information that should influence you any more than anybody else's.
Yeah,
information.
I hear what you're saying. I feel a little uncomfortable having members of the audience go back and forth about each other in front of us, and I do think that if the Mid-Coast Community Council wished to say anything to us, they certainly can say something, and as I'm understanding, she made clear that she was not speaking, had not cleared her comments with them, so.
It was on stationery, so that would behind her, and the map was too. All right, but it's not accusatory. I have nothing against Ms.
Okay.
Carter. It's about how the information comes to you and the validity of it, and the regulations that you're supposed to be defending for us can be easily said, well, you met the standard, but I'm not happy.
Well, and just to clarify on that, I think our staff made quite clear, I think this is again off the subject of the item before us, but since we just recently were there are numerical standards, and if something doesn't meet those numerical standards, it shouldn't even go before the design review committee. The staff should say, it's got to be changed. But there are subjective requirements that are judgment calls. And what I heard Commissioner Wong say is, gee, I guess this does meet the numerical standard, but there are 1, 2, 3, count them, subjective requirements I don't think it meets. And that's a judgment call, and, again, it can be appealed to the Board of Supervisors, and if they're unhappy with our judgment, they don't have to reappoint us. We serve at their pleasure, as I understand it, and they serve at the pleasure of the public. So,
I'm not
Yeah.
accusatory of
Mr. Chair.
wrong as an example.
and I'm maybe indulging us getting too far off the subject, but I wanted to answer your question.
Yeah.
Thank you.
Yes, I clearly remember that Ms. Carter prefaced her remarks by saying that she is expressing her opinion, and not that of the Mid-Coast Community Council.
Well, and I think even Mr. Pellegrini acknowledged that, so I'm wondering if it's a non-issue. In any case, we'll go on to
move on.
the next speaker, Leonard Warren, to be followed by Chuck Kozak.
Good afternoon, Commissioners. This is an item that I feel really strongly about, and this is basically the first time where I have completely, absolutely disagreed with staff all the way down the line. I'm referring to Task 22. I don't believe I'm going to comment at all on Task 23 other than to point out that you have a letter from the Granada Sanitary District Board written by our council. I've discussed the Task 22 with two lawyers intimately familiar with coastal land use and the Coastal Act. And a year ago, I got email from one of them on this. And what he writes is, Policy 1.1 of Half Moon Bay City's LCP specifically adopts Coastal Act Sections 30210 through 30264 as the guiding policies of this land use plan. These are the key natural resource protection sections of the entire Coastal Act, and they relate to public views, special habitat, streams and riparian areas, and wetlands. Page 3 of HMB's LCP checklist lists what is covered. There are no equivalent protections in the county's policies. Commission authority over coastal zone land use is solely derived from the Coastal Act. Just about everything the Commission says with authority is based on the words of the Coastal Act, as are court decisions regarding their right to say it. The fundamental premise of administrative law, the kind of law land use agencies exercise when they make permit decisions, is that it must be based on statutory, not local ordinance authority. An LCP is not a statute. The Coastal Act is. The more statutory language an LCP has, the more defensible it is, and the more assistance is available from the Commission and AG to do so. Thus, the more statutory language the county had in its own policies, the less tendency there would be for either applicants or environmentalists to sue the county's LCP. I have to adjust some of this because this is a year old and it's not based on the current staff report. The county states that Coastal Commission's certification of its LCP means that its LCP is the functional equivalent of the Coastal Act. Thus, there is no reason to adopt any portion of the Coastal Act because, quote, all relevant Coastal Act provisions have been incorporated or adapted, end quote. The county is incorrect because its approach makes the LCP weaker than it would otherwise be without a public purpose justification. In addition to weakening the LCP's protective scope and legal basis, the county's approach is vulnerable to appeal by coastside residents and government agencies. When such appeals present substantial issues and a lack of Coastal Act or comparable county policy sounds like one, the Commission can assume jurisdiction, thus putting at risk the time and money the county has invested in local content. Can I go on?
I'll give you 3 sentences, which is 2 more than I ought to, no offense. It's been a long day.
I understand that.
Listen, I'll give you 1 more minute. Don't have to, so you can say your sentences more quickly than trying to pick out which 3 they're going to be.
Well,
But please wrap it up.
I'm just scanning down, trying to pick out what the most important things
Concept.
are that I want to say. Note that Half Moon Bay's LCP is much more modern. I believe it was certified in 1996, and it's very common now for these Coastal Act sections to be approved. San Mateo County's was the first LCP approved. The experience wasn't there back then. I think what I'll close with is that the LCP can be more restrictive than the Coastal Act, but it can't allow things that the Coastal Act doesn't allow. So the redundancy issue, I think, is a spacious argument, and I think there is, as the lawyer wrote in the email here, I think there is nothing to be lost by incorporating these, and there's a lot to be gained by improving the Coastal Commission's ability to enforce the Coastal Act and therefore the LCP. And I very strongly urge you to incorporate at least sections 30210 through 30264. And I believe Half Moon Bay is actually expanding that list, but I was unable to get specific information. Thanks.
Thank you. Chuck Kozak to be followed by Catherine Slater Carter. And then, well,
Good afternoon. Again. Chuck Kozak, 1465 Buena Vista in Montero. I'm going to do 23 first. I'm in support of the recommendations that are in agreement between staff and Mid-Coast Council. But there was one issue regarding that that actually just occurred to me, and so I'll bring it up so maybe George can think about addressing it. And this has to do with much larger parcels. The idea of sort of stormwater filtration and lot coverage works well on small residential parcels because you always have coverage, some vegetation coverage, some vegetation, yeah, okay. With larger parcels, say a 20,000 square foot parcel or a 1 acre parcel or a 10 acre parcel, which we have within the study area, you could have some rather large, massive 1 acre concrete patios, which is a little, maybe not what we're trying to do here, because you would have sort of a concentrated runoff situation developing. The thought that comes to mind is because we have within the residential zoning, we have a 6,000 square foot, is that right? 6,200 square foot FAR limit, that this impervious surface should have a similar top surface, should have a similar top limit to it, which that would be for about a 13,000 square foot parcel. It's where the house size tops out. Maybe the impervious surface, this should also top out at about whatever that comes out to be, 1,300 square feet. So we don't have large, really large impervious.
I think we
surface
understand
pieces.
the point you're making.
Okay, good, thank you. On 22, I'm in agreement with staff. I'm in agreement with Leonard to a point, but I have to admit I'm a little confused now that I've started thinking about some of the ramifications involved there. And when I was on the council and I worked on the council's recommendations, our intent there was to have the most inclusive and most protective policy developed regarding this. I agree with the new policy based on Coastal Act Section 30007.5, certainly. The inclusion of the Coastal Act, now I'm wondering what happens if the Coastal Act gets changed. Things like Coastal Act compliance of LCPs tend to be politically driven sometimes. So to say that, because we have a compliant LCP that was that was approved back in 1980 may not necessarily make it the most reflective of the Coastal Act policies or means, and that could happen again in the future. So I'm actually going to let you know I have no recommendation on that one at this point, and I leave it to your collective wisdom to come up with a good solution. Thank you.
Thank you for the compliment. I hope we deserve it. Catherine Slater-Carter, followed by April Vargas.
Good afternoon. Catherine Slater-Carter, and I am chair of the Mid-Coast Community Council, and I am here right now reflecting the discussions that took place during during the creation of our recommendations. First, I want to compliment George and the staff for doing an excellent job in raising issues that we hadn't considered during this process. They do give us pause for thought. The Mid-Coast Council position was created because we had seen a number of apparent differences between our local coastal program and the current Coastal Act, and we felt that in certain cases our own coastal program was not as protective as it possibly could be. I think the intent of our recommendations were to get as protective of natural resources and coastal resources. That also includes human resources and other all of the full spectrum of cultural resources that we can have. The MCC specifically recommended investigating other jurisdictions that have included this language from the Coastal Act in their own local coastal program. Leonard mentioned Half Moon Bay, and we were hoping that staff, or through the knowledge of County Council, could do a small amount of research and see how those had been working. Indeed, if you look, every chapter in the local coastal program begins with the county will and has a set of policies. But in fact, our program is a much larger document. And there's actually several volumes that predate that give the genesis of where the policies came from. And I think it's important to be cognizant of that when you're seeking to apply the policies and have the protections. As to Task 23, I was before this council, the commission rather, probably 5 or 6 years ago, talking about the flooding problems in El Granada that had been created by development uphill and the lack of any kind of impervious coverage standards. I think this is timely, and I hope it can get implemented as soon as possible. I would suggest that staff have some kind of document, maybe one of the flyers on the wall, that actually recommends porous and pervious surfaces as the first solid surfaces that are put down, as opposed to having to do some kind of calculation and then move to those. The more they're used, the less expensive they'll be, and they are available. Lake Tahoe and TRPA has a lot of information on that. I'm going to finish up by saying that particularly in our area with all of the urban wells, we need the recharge, and so that's why we need this to go in very soon. The other is that under STOP and under some of the federal Clean Water Act stuff, they're getting more stringent on protecting runoff into the ocean, and I really would hope that the implementing ordinances will be reviewed on a fairly regular basis to keep things up to date. Thank you.
Thank you. April Vargas, to be followed by our last speaker, Dennis Doherty.
Good afternoon, Commissioners. My name is April Vargas. I live at 377 12th Street in Montera, and I'm speaking this afternoon on behalf of Committee for Green Foothills. I want to start off by pointing out that the committee has modified our original recommendation from the one that was contained in the letter that I sent to you. I think it's almost a year ago now. We appreciate the detailed analysis presented by staff within the staff report, and after subsequent examination and investigation, the committee finds that we are in agreement with staff's recommendation on Task 22, and quite specifically, Mr. Bergman had said that there would be language that he would draft subsequently for language that would be consistent with Act 3007.5. And I guess my initial question was why the language that was here that was highlighted in orange wouldn't be sufficient, since that's definitely is the committee's, as is the Mid-Coast Council's primary consideration, is that when there are conflicts in interpretations and complying with requirements, that they always be resolved in a manner which is most balances and is most protective of significant resources. One other point that we'd like to make is that regardless of what parts of the Coastal Act would be potentially included as part of the LCP, that enforcement is absolutely the key component to ensuring that San Mateo County's LCP upholds the provisions of the Coastal Act and provides the protections that the coastal resources deserve. So I believe that that's the most important thing, is that enforcement of our local coastal program always be very specifically entered into. As far as Task 23 is concerned, as was outlined by Mr. Bergman again, the provisions in Task 23 were developed in a public meeting that was attended by a very broad spectrum of the community that included elected officials, owners of commercial properties and businesses, members of the construction industry, members of the Design Review Committee, and also Mid-Coast residents generally. The policies that you see in front of you in Task 23 are essential to limit stormwater pollution and improve our marine environments. And this recommendation definitely addresses impacts also in our local neighborhoods where new construction is occurring, and with runoff problems, flooding of neighbors' lots, muddy water going down the street, and all those other problems. So the committee enthusiastically urges you to approve Task 23. Thank you.
Thank you. And our last speaker.
My name is Dennis Doherty from Moss Beach, and I'm a home builder, and I work mostly on the coast. And I'd like to, I'm speaking to Task 23, and I'd like to say that I support Task 23. I think it's an effective way to, from a builder's perspective, to reduce the both the stormwater runoff and the erosion and sedimentation that occurs as a result of typical construction projects. And also, regarding Chuck's upper limit, I think that's a reasonable upper limit of 1,300 square feet. That anything beyond there, for larger parcels that are several acres, I think 1,300 would still be a fine impervious surface limit. Thank you.
Thank you. Is there a motion to close the public hearing?
So moved.
Second?
Second.
All in favor?
Aye.
I just wanted to respond to the testimony from Chuck Kozak and Dennis Doherty about putting a cap on the amount of impervious surface. We would support that, recognizing that there is no cap at all. I mean, right now, we're not even controlling it, and to have a more comprehensive control, it is important that we look at large parcels. I think Chuck's suggestion of keying it to the same formula that we used with the house size, which was the largest house size was 6,200 square feet. If you determine the parcel size that corresponds with, and then put the 10% of that, then they'd be in sync. And I did quick math. It's not 1,300. I came out at 1,170, but it's the same approach. And so we would endorse that. And that's what I wanted to.
George, one question, or I should ask, are there other members, other commissioners who have questions of staff? George, one thing, and I think maybe I've got my own answer to this, but one thing that occurs to me about impervious surface limitations, I think it's important to have them, and I think some kind of cap, or is the lot, there's less need, on a smaller lot, there can be a greater need for equitable development to have a higher percentage of impervious surface. I think some type of, either like this, the suggestion of having a cap, or I've seen communities that have a declining percentage as the lots get larger, and then a cap. But I mean, either approach can rationally, there's a rational argument in favor of some type of approach like that, of which there's more than one possible. But sometimes increased impervious surface is necessary for better design, and if, because of the particular circumstances of a lot, say having a longer driveway is going to produce better siding, maybe more impervious surface, even though we hate to see it in terms of runoff, it might yield other planning goals. Of course, I think I see the way around that is that that the way impervious surface is designed, there are, for instance, for a driveway, there are certain surfaces that would be, at least to an extent, permeable.
Yeah, that's what I was going to pick up on. As described in a little more detail in the staff report and as touched on by Catherine Slater-Carter, what is available to the building industry are more and more products that are of a porous nature there, and their prices are coming down the more people use them. And my understanding that there are impermeable concretes, asphalts, rocks.
Right, and you did cover that, so I guess to answer my...
That would be,
yeah.
You could use those over the limit.
So, right, so if indeed there'd be ways to achieve these planning goals that are permeable.
That's right.
Okay.
I'd like to endorse your comment, though. I think we ought to, I think that suggestions are good, but as we move forward, I think we ought to look at that driveway issue a little further, because my concern would be cost trade-offs, and I agree with Commissioner Silver. I'd hate to see us in an argument with an applicant about getting resistance on a good site planning solution because of the cost of a long driveway out of, paving stone versus asphalt or something. So I think we ought to, as we move forward, we could see how other communities handle that issue, and we're just, I think, kind of mainly, I was thinking the same thing, the parcel that needs a long driveway. And I agree with George, there are probably solutions to that, but I think we ought to we have time to work on that.
And and I just suggest, if we need an escape valve, it could be, if in the interest of overall superior design, more, findings could be made that would allow an exception up to a certain amount, potentially. I mean, at least that staff can look at that and bring that back.
I think we were focused on that.
If the commission is agreeing.
Well, the other thought that occurs to me is that we've made the recommendations have a specific recommendation for non-residential parcels that says if you need more pervious surface for one reason or another, then you must design it so that you don't get more than 10% runoff. And that can be by capture and dry wells or cisterns or something like that. It may be that one of the things you might want to think about when you come back on this is that for large parcels it may be appropriate of a residential nature, it might need the same escape valve.
Are we, I don't want to be presumptuous, but are we ready for a motion on this? For items 22 and 23? Or we can do them separately? How about task 22?
No, I'll move the staff recommendations for item 22 and 23.
I have a second.
Under discussion,
Well, we'll talk about it, but
under discussion, we had the suggestion during the public hearing that George Bergman and I believe Terry Burns endorsed to have to look at a cutoff on impervious surface that would be in sync with the largest house size. Do we want that modification?
I would include that.
And in addition, also that staff would look at exceptions to impervious surface and or the kind of recapture of runoff that you just spoke of that it might be necessary to provide for superior design.
I will include that as well.
Does the seconder include those?
As a seconder, I will include those in my second.
Any further discussion? All in favor?
Aye.
Aye.
Well, congratulations, everybody, and thank you. Under correspondence and other matters, there's one other matter I do want to come back to in a moment. There were 3 items that I wanted to bring up, but it's been a long day. I'm happy to bring these up at our next meeting instead. There was some correspondence about some Ladera concerns that were other than the Ladera Oaks Club. I wonder if that would be worth just tagging and bringing up at the conclusion of our next meeting, unless people really want to go into it today.
No. I just want to clarify, you did get the memo.
I did.
Okay,
If we could redistribute it with the packet next time, that way I won't forget, and perhaps note it under, correspondence and other matters A, so it's specifically noted and we don't forget, because otherwise I might. I find if I don't, this month I have forgotten 3 appointments that I didn't write down. So I got to write it down, so I'm not going to remember. The other is the board action on the housing element. I just assume they already acted, it's not urgent, but why don't we I was there, and I think Carrie and Marcia were there. We can report on that next time. And I'm not sure if we need to take this up, but there is a correspondence about flooding on Cedar and Date Streets in Montera. Is that appropriate for us to discuss, but maybe at our next meeting? Just to get a report on it?
I just ask quickly, did you get, there was a letter from a resident in that area. I think you got a copy of that. And then I'm wondering if you got the response to that was sent out by the Department of Public Works.
Well, yes, that's the 2 things I'm looking at.
You got
February
both.
21st letter from a number of residents addressed to a number of people in the county, including us, or including me, and then the response, yeah.
You did get both of those? Okay.
Yeah, I've got them right here. And I can either give it back to Candy to send back to me, or we just read it.
We'll put all 3 of those on
Give
the
it back
next
to
agenda
Candy.
and put them back in the
A, B, and C under other matters, because, again, otherwise I'm going to forget. And the last other matter, and one I don't want to put off for next time, we already talked about a little. I'm damn disappointed and teed off that we're losing one of our 2 bills.
You're losing the bogus bill.
I don't know about that.
I have to ask a special privilege of the chairman, if I can, if we're ready. Terry, you have anything else to say?
I did want to bring up
Please,
one
would you do that?
just quickly. Yesterday, the board upheld the commission's decision on a design review appeal in Emerald Lake Hills. This was the project that David Klausner had taken issue with. It was a new house with a second dwelling unit. You wrestled with some of the landscaping and other things, but they upheld your decision. I wanted you to know that. And then secondly,
That's nice occasionally.
I think, I don't know if we had anything in your packet this time, but ex-Commissioner Bergeron, now Superior Court Judge Bergeron, has suggested to us several times that we try to organize another Planning Commission reunion, lunch, dinner, picnics, whatever. And we did some surveying of past commissioners that were interested and responded to that. I think we got a fair showing of interest in that. Candy, can you help me remember what the preferences were? Well, hold on.
It was 3 for a dinner and 1 for picnic and 1 for
Most were for dinner or lunch? Okay, so
Plus 1.
what we'll do is, I just wanted you to be thinking about this. We'll put a little memo in your next packet summarizing what we heard from other commissioners. And then what we'd like to do is get some direction from you on, I think you said before you'd be happy to do this, but then sort of how you'd like to do it among the different things that have been suggested, because we'd like to, you'd really be hosting those other people, and it's sort of your party. We'd want it to be what you want to do. And the choices basically were to join you at lunch someday, probably on a day when we would be done by lunch with some reliability, go to dinner together, or possibly a picnic.
Remind them of old times. We used to have them for sandwiches an hour and a half late.
There you go. And
In case they're being falsely nostalgic, that'll cure them in a hurry.
You know, if we're through, I tried to beg the chair's
know.
indulgence, so if you're through, Chair?
yeah, and the only other thought was that, Commissioner Bergeron had suggested perhaps at a location that the commission had some role in protecting, and I wasn't quite sure what that would be, but that's a thought to plant. And so we'll take that up next time, but we'd like to sort of reach a decision on that so we can start to organize something and be sure it happens this spring or summer while the weather's good, and not get, drift off in the next year.
And I'd like to make sure that it's very expensive. I would like to see if I could make a motion that would pass with unanimity today, and I would like to make a motion that we adjourn this meeting.
Is there a second?
Oh, well, geez.
He's going to die because
He's gonna die
Second,
from-
second.
No,
Aren't you
people
gonna-
get up and leave, it dies for lack of a quorum, because we've all left.
Aren't you going to amend that and to be in Bill's honor or something?
Oh, yeah.
Or is that only for people who are,
I made the motion.
He made the motion, so,
okay.
We could ask the mover to accept the, what a debate on this?
Oh, yeah, we have a debate, yeah.
So just so that everyone understood, this is not, I think the way Commissioner Kennedy announced this, it caused some concern among people, but it's really there's nothing unhappy about this event.
Is this your last meeting?
Well,
It
we
is.
the odds are probable. In other words, do I go to the spirit of the law or the?
Best to follow the letter.
Yeah, don't,
Mike did.
yeah, don't talk to me then.
Mike did check this morning, and his conclusion was once you're no longer a resident of the county, you may no longer
That's
serve.
right.
So you're correct about that.
Not even until you're replaced?
No, that's if you
Not
if
even
you're
if
still
You
in,
haven't been reappointed.
Not even until I sell the premises.
if you're still in the county, then that works, but not if you.
I didn't ask
so
that.
when he relocates his place of residence, then he can no longer serve.
And we're talking permanent residence, if it's a situation like you're only temporarily moving, but you're gonna move back to your house or something like that, you're okay, but if you're out of here,
You're putting me
you're
in-
out of here.
You're
So
not
when you-
really putting me in a rock and a hard place
No,
for a
but when you-
change.
So if you move to Petaluma, that's it. And it's a
So this probably.
for you.
Yeah, it's probably a.
Life is
fait
tough.
accompli, yeah.
Life is tough.
Fait accompli.
no more traffic.
But I'm very disappointed that we didn't get a very expensive lunch on the county.
Today?
Well, that's why we'll have you back for the reunion.
Well, and we still have we're still getting Billy's resolution and stuff.
Oh,
I think.
These things take time. You
Suitably
need
framed.
And we will have you back at some point for a little recognition, I think.
Now, you've done so well interpreting for me today, I was going to quote some Greek for you and see if you could
There you go.
interpret that.
Mr. Chairman, are we voting on the motion?
Are we voting on? I think it's
Lack
gonna.
of quorum.
That's not, they didn't, yeah.
Get up and walk away. No. Was there a second?
There was a second.
All in favor? Aye.
I think
Your last motion is.
You guys made me work like heck.